Keys to real estate law. Real estate law is a sophisticated tapestry of federal oversight, state statutes, and local ordinances that collectively govern how land is owned, used, and transferred. Because land is immobile and unique under the law, it requires a specialized legal framework distinct from personal property. Comprehensive analysis of real estate law. The multi-jurisdictional nature of property law. Real estate law in the United States is primarily the domain of individual states rather than a uniform federal system. While federal statutes like the Fair Housing Act and RESPA provide a baseline for civil rights and lending transparency, the core bundle of rights is defined by state law. Each state determines the formalities required for a valid deed, the process for foreclosures, and the specific duties of disclosure owed by a seller. Consequently, a transaction in California involves vastly different legal requirements in standard forms than one in New York. This fragmentation necessitates that legal professionals maintain deep, localized expertise to ensure compliance with the specific jurisdiction's civil codes. The doctrine of estates and ownership interests. At the heart of the legal framework is the doctrine of estates, which categorizes the duration and nature of an individual's interest in a property. The most absolute form of ownership is fee simple absolute, providing the owner with the fullest bundle of rights allowed by law. However, property can also be held in life estates, leasehold interests, or through joint tenancy and tenancy in common, each carrying distinct implications for inheritance and liability. Understanding these interests is crucial because they dictate who has the right to possess, exclude, or encumber the land. Mistakes in identifying the type of estate can lead to clouded titles that prevent future sales or result in unintended inheritance disputes. The Statute of Frauds and contractual integrity. Real estate transactions are governed by the Statute of Frauds, a legal principle requiring that any contract for the sale of land must be in writing to be enforceable. This requirement exists to prevent perjury and to ensure that the complex details of a land transfer, such as purchase price, contingencies, and legal descriptions, are clearly documented. A valid real estate contract must identify the parties, the property, and the consideration or value being exchanged. Beyond simple agreement, these contracts often include condition precedents, such as financing or inspection contingencies, which allow parties to exit the deal without penalty. Without a rigorous written agreement, the transfer of real property remains legally precarious and prone to litigation. Title examination and the recording system. The title to a property represents the legal evidence of ownership, but it is rarely a simple, singular document. Instead, U.S. law relies on recording acts, where deeds and encumbrances are filed in a local county office to provide constructive notice to the public. Title examination is the process of searching these public records to ensure the seller has a marketable title, free from undisclosed liens, easements, or claims from long-lost heirs. To mitigate the risk of hidden defects that even a search might not find, buyers almost universally purchase title insurance. This system ensures that ownership remains traceable over decades and protects the buyer's investment from historical legal claims. Land use, zoning, and public control. While private ownership is a cornerstone of American law, it is not absolute and is subject to public control through zoning and land use regulations. Local governments exercise police power to divide land into residential, commercial, or industrial zones to protect public health and welfare. These regulations can restrict everything from the height of a building to the number of families living on a single lot. Property owners may seek variances or special use permits if they wish to deviate from these rules, but these processes involve public hearings and legal scrutiny. Understanding zoning is vital because it determines the highest and best use of the property and its eventual market value. The law of mortgages and secured financing. Most real estate in the U.S. is acquired through secured financing, where the property itself serves as collateral for a loan. This relationship is governed by the law of mortgages or deeds of trust, depending on whether the state follows title theory or lien theory. In a lien theory state, the buyer holds the title while the lender holds a security interest. In a title theory state, the lender technically holds legal title until the debt is satisfied. Financing law also involves strict federal regulations like the Truth in Lending Act, or TILA, which ensures borrowers are fully informed of their financial obligations. If a borrower defaults, the law provides a specific foreclosure process that must be followed to protect the debtor's equity and rights. Landlord-tenant relations and habitability. Landlord-tenant law is a specialized subset of real estate law that balances the property rights of owners with the possessory rights of occupants. Modern statutes have moved away from historical caveat emptor, buyer beware principles towards protecting tenants through the implied warranty of habitability. This legal doctrine requires landlords to maintain properties in a safe and livable condition, regardless of what the lease says. Additionally, states regulate the eviction process, requiring formal notice and court proceedings to remove a tenant, thereby preventing self-help evictions. These laws are heavily influenced by local rent control ordinances and state-specific security deposit limits. Easements, encumbrances, and property boundaries. Property ownership often involves sharing certain rights with others through easements, which are legal rights to use another's land for a specific purpose. Common examples include utility easements for power lines or easements by necessity for landlocked parcels to access public roads. Beyond easements, encumbrances like tax liens or mechanics liens can attach to a property, effectively running with the land even if the property is sold. Accurate legal descriptions and boundary surveys are essential to define the physical limits of these rights. Disputes over encroachments, such as a neighbor's fence crossing the property line, are among the most frequent causes of real estate litigation. Environmental regulations and liability. Environmental law has become an integral part of real estate transactions, particularly through the federal CERCLA statute. This law can impose strict liability on property owners for hazardous waste contamination, even if the current owner did not cause the pollution. Consequently, Phase 1 environmental site assessments are a standard part of due diligence in commercial real estate to identify potential liabilities before closing. State laws also mandate specific disclosures regarding lead-based paint, asbestos, or radon gas in residential sales. Failure to comply with environmental regulations can lead to massive cleanup costs and a significant decrease in property value. Eminent domain and constitutional protections. The power of eminent domain allows the government to take private property for public use under the Fifth Amendment of the Constitution, provided just compensation is paid. This power is often exercised for infrastructure projects like highways, schools, or utilities, but its scope was famously expanded by the Supreme Court to include private economic development. Real estate law provides a framework for condemnation proceedings, where the owner can challenge the necessity of the taking or the amount of compensation offered. This intersection of private rights and public needs represents the ultimate limit of property ownership in the United States. It ensures that while ownership is protected, it remains subordinate to the broader requirements of the sovereign state. We welcome you to subscribe to our YouTube channel for more informative videos on real estate, business, and the law. Thank you.